Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Welcome to our show, and thank you, Michael, for the introduction. Don, welcome back to the show, and I know we're doing this on a monthly basis, our legal tip for our show. But the people that haven't seen you in our previous shows, would you just give them a little background about yourself?
I'm an attorney here in Naples, a member of Ross, Lanier & Dyfic. I'm also the owner of Ross Title and Escrow, and I'm also an owner of Downing Fry Realty, Inc., one of the owners. I've been practicing since 1982. I'm almost exclusively in real estate with some tax.
And where's your offices located?
I'm right on 41, the corner of 6th Avenue North and 41. We're on the west side, right up from the Capital Bank.
And maybe you could just tell our viewers a little bit about your team that you have there, because I know, we use you a lot, and that it's, it's a good team. So maybe you could just tell them how everything works in your office.
Well, we have it broken down to stages. We have a bookkeeper, we have an IT person, we have 4 paralegals who handle closings. We have 2, we call them pre-closers, who open files, order estoppel letters, order title work. And we have a post-closing person who orders the follow-up title search and sends out the recorded deeds and final policies to the customers. Been together, most of them for, my office manager, 27 years, all the way down to 2 years.
Okay. Don, I know we've been doing several shows in the past months here, and we've covered different topics. Closing cost was one that was pretty well received and got a lot of views in contracts. And the show today, I think what we're going to go over is addendums to sales contracts. Okay. Because it's important that people, our viewers, the consumer, and even realtors understand the dynamics of these addendums that go on with a contract. So we have, I don't know how many we have here, 20 or so, but we'd like to go over one by one and just give us your input from them. So the first one is the right to inspect, the right to terminate. So maybe you could explain to everyone what that really means.
Well, I refer to it as the free look provision. It gives the buyer a certain period of time to do whatever investigations they want and terminate the deal within that time period, get their deposit back, and walk away if they so choose. It's a very flexible document, and there's actually 2 of them. The one that goes with the standard inspection clause and the one that stands by itself, which is strictly the right to inspect and terminate in buyer's sole discretion for any reason or no reason.
Right.
It's commonly used when a buyer has a multitude of issues, and rather than having 14 contingencies to the contract that might intimidate the seller, they incorporate those 14 issues into one right to inspect and right to terminate addendum. It looks simpler.
Right.
It's the 10-page contract plus this 1-page addendum. So psychologically, it's something that a seller would be less apt to bring to their attorney and have their attorney pick apart and send back.
And the timetable is typically 15 days, right?
It's typically 15 days. That's the default time period. You could have a situation where it's a tear down and the buyer wants to consult with an architect and a builder and the building department, and they might need more time. So I do see situations sometimes that they're shorter.
Right.
Psychologically, the longer the period, in my experience, the longer the period, the more apt they are to fall apart. So you have to balance all those issues.
And the terms can always be negotiated, the time period.
Absolutely.
Then the next one we have here is an as-is addendum. So we have a regular sales contract, and then there is a box there you can
Sure.
do it as an as-is contract. So what does that mean?
Well, the main contract is this 10-page
That's right.
document. You go to paragraph 6, and it has 3 options. There's 6A, which is the regular inspection paragraph, where you have 15 days to do your inspection and 20 days to make your election on whether you want a credit or remediation. And that is tied with the first addendum that you and I just talked about, okay? If it's not terminated within that time period in the first addendum we just talked about, then 6A kicks back in and remains in full force and effect, and the buyer has the right to ask the seller to either fix certain things or for a credit.
Right.
Now the seller has the right to say no under 6A. And if the seller says no and it's something that's legitimately requested, the buyer has 5 days to cancel. So my experience with this, if I'm representing a buyer, it's a lovely thing. I don't have to argue about whether something's in working condition or whether it's cosmetic. I don't have to argue about how old the air conditioner is and what's it worth. I can just say we want this or we're going to cancel. I try to back that up with actual estimates of whatever the repair issue is, so the seller doesn't feel like you're trying to reach into their pocket or renegotiate the price, that this is a legitimate repair issue. This is what the buyer was told it would cost to fix it, and this is what we're asking the seller to address. If you just pick a round number, the buyer's asking for a credit of $5,000 or $10,000, people tend to be a little skeptical of that. They want to see some backup, see if it's a real number.
That's right, exactly. And people that are selling properties, typically that would be the addendum that we would use if they're asking to do an as-is contract, if it's a NABAR contract.
Yes, you'd use, yes it is. And it's commonly used up in other parts of the state as well.
Right. The next one we have here is seller right to backup contract to the primary contract. What's that mean?
This, I'm sure I'm going to make a lot of enemies, and I'm sure there are people who will disagree with me. I don't really like this form at all.
Well, that's good you're being truthful.
Well, I just don't like it. I don't see it that often. I've done anywhere between 20 and 30,000 closings in my career. I don't see it that often. I mean, I see the issue come up, and I have to draft language to specifically address it. But the best way to illustrate this, what this form does, it has a fill-in-the-blank portion of it where if the seller has the right to continue to market the property, if they get another offer, they're supposed to notify buyer number 1, who already has a fully executed contract, that they have a backup offer. They got to show it to them. And then the buyer has a certain period of time to say, okay, I'm putting more money down towards my deposit.
Right.
Okay? And so, buyer number 1 still is the person buying the property. Buyer number 2, who made the offer and it wasn't accepted yet, is not buying the property. Now, the problem with this, in my experience...
Your attorney, a legal experience?
My legal experience. Okay, let's say you have a fully executed contract for $200,000.
Right.
And you filled in this addenda to say that if you get a backup offer, the buyer number 1 will put an extra $5,000 down towards their $20,000 deposit. So instead of $20,000, it's $25,000. You get the backup offer. It's for $250,000. You already have a signed contract for $200,000. So the most the seller is going to get is a bigger deposit. They're not going to get more money for the sale of that property.
Right.
Okay? And buyer number 1, I can assure you, will probably go forward and close and then hunt down buyer number 2 and sell it to them for more money.
Right.
So you're going to have a very unhappy seller
Right.
because they didn't get to accept the second contract. I mean, I usually come up with something a little different where the buyer has X number of days to match, the backup offer, and comply with its terms and conditions so that the seller gets their $250,000.
Okay.
I mean, it depends on which side you're on, how you're going to play it. But the way this is, it's a good concept, but I almost never use the form.
Okay, well, I'm
Sorry.
glad you're being truthful. I certainly won't either.
Well, it just depends on who you're representing.
Exactly. So the next little addendum that we have here is appraisal contingency, which can always be interesting, right?
Well, yes. And appraisals, to preface this, are something that I think are greatly misunderstood. Generally, they'll have 3 comparable sales and maybe 1 pending sale. Most people on the street, they think that the appraisal is real. This is really what the property's worth.
Right.
They don't realize, as they teach in real estate school, that it's an art, not a science. They're using other transactions that happened. It could have been months ago, it could have been last week, it could have been another development. If the market is not very active, the appraisal is really, really weak.
That's right.
If the market is super active, it doesn't necessarily take into account the appreciation. How much is it going up per month?
Yeah.
And the modifications they make under the appraisal process. I mean, I know just from my own home, some of the modifications when we had the house appraised last were just a joke.
Right.
I mean, what modification they would make, say, for a pool with a screen enclosure. They might make $10,000 when it costs $30,000.
Right.
So that's the preface. The appraisals, I always tell my clients, they're a guesstimate.
That's right.
Okay, it tells you if you're in the ballpark. If you're getting a loan, these come up all the time. And I tell my clients, if you're going to waive your financing contingency, you need to have backup money in case the appraisal is a little low, because banks tend to be conservative with their appraisals. Here, this form, it allows the buyer to get an appraisal, and if it's low, notifies the seller that it's low, and the seller has 5 days to either drop the price to that number, or the buyer may cancel the contract and get their deposit back and walk away. Once I explain to the buyer or the seller that the appraisals are a guesstimate, and I usually give them a few actual examples that I've been through, I tell them, you want to use this for 2 reasons. One, to make sure you're not getting a bad deal.
That's right.
It's close. Okay. 2, that you're going to have enough money to buy it if you're getting a loan.
Right.
If it's not exactly what it is, the bank might lend a few dollars less, and you need to have the excess funds. So that's how I use it.
Okay, well, Don, we're going to take a little short break, and we're going to be right back in 1 minute.
When picking a realtor, don't just pick anyone. Pick someone with experience. Pick someone with a proven track record. Pick a realtor like Jim York from Downing Fry Realty, the #1 brokerage with the most real estate transactions in the area.
My husband and I had very specific ideas about what we wanted in our new home. Jim York was able to help us find the home that was ideal for us.
With over 20 years of real estate experience in Southwest Florida, Jim York has negotiated over $200 million in sales contracts. Selecting the right realtor is a critical decision that can earn you thousands when selling or save you thousands when buying.
Jim also helped us with a mortgage lender and a good real estate attorney. He went that extra mile, and his experience says it all.
Call Jim York for a no-obligation meeting at 239-273-6727 or visit his website, www.naplesyorkrealestate.com.
Welcome back. Don, let's go back to the addendums again here. Defective drywall, I know we had a lot of Chinese drywall here and all over the country, really. So this is an addendum to cover the buyer on this, so maybe you could explain what this consists of.
Well, this is a disclosure to the buyer whether or not the property has been built or renovated using some potentially defective drywall that gives off noxious odors, poses potential health risks. As the attorney for Downing Fry, I can say we've had a number of agents sued over this for not including it in their contract. The point of this addendum is to let the buyer know that Chinese drywall or defective drywall is out there, and they know that it's out there, and they can conduct whatever tests they want for that if they want. The complaints, and I've reviewed them against the particular agents, they all allege that the selling agent knew of the existence of this defective drywall, not necessarily in the house, but they knew it was out there, and they failed to inform the buyer. And a lot of agents weren't getting this signed because the seller would refuse to sign it. In many cases, the seller was a bank or a federal institution,
Right.
and they're not going to sign anything.
Right.
So I said, well, if we can't get both, and it's sort of a normal impulse for a realtor, that if the seller and the buyer aren't both signing it, it's no good.
No good.
Well, in this particular case, if you just get the buyer to sign it every single time, it's going to protect the agent, because the buyer is the one who's going to sue, not the seller. The buyer will sue in this case. They're the ones who own the house.
Right.
They're the ones who are going to discover whether there's defective drywall or not, and they're going to want to get paid for it. So just to get the buyer to sign, if the seller refuses to sign, and you'll be in pretty safe.
Okay, and then next addendum we're going to go over is lead base paint. Maybe you could explain that. I know that we don't really have that as that common here, but because it goes back to the age of the home.
Well, it's federal law. Anything built, residentially prior to 1978, you have to disclose to buyers that lead poisoning poses health risks to young children. It can create learning disabilities, reduced intelligence quotient, behavioral problems, and impaired memory. And I used to think, honestly, when this first came out, that
You had it?
yeah, that I had it, and also that the only way you get it is by chewing on the window. And I said, no, it could be somebody could be sandpapering, it could be just floating through the air, and it could be a real issue. So if you have one of those historic homes near the beach somewhere, and it's prior to 1978, you most definitely want this. And there's a booklet that you provide. There's blanks that you can check off here, are blocks where they waive the opportunity to have the inspection for the lead paint. You want to keep copies of your disclosures. You keep copies of your emails disclosing it, because that's something the courts look at. But you're right, it doesn't come up that often, but it's nice to know it's there.
Okay, the next addendum we're going to go through is the CDD and the MSTU. What's the purpose of this?
Well, this ties into the main contract, this
Right.
10-page contract. We have a page 5 where there's 2 check boxes, one that says it is not in a commercial development district, or it's not subject to a municipal taxing fee. But if it is, and this form is filled out, the buyer agrees to take title subject to that, and they assume the payments. Now, the CDD is usually the developer raising money by selling bonds to build the infrastructure of the development. And then it's incorporated in the ad valorem tax bill. And the buyer's just assuming that, okay? There is a payoff, and if it's a significant payoff, you can always write into the contract that the seller agrees to pay it off. The MSTU is generally maintenance. If you're in an HOA, it'd be the lawn care for the meridian and things like that, and it's an ongoing fee. There is no payoff, and you're just notifying the buyer this is what it is, and you agree to pay it.
Yeah, the CDD is it's a bond.
It's a bond.
It's a bond, and it can be renegotiated at any time too. During the period of.
But a lot of times, I mean, it's right here in the form. It's customarily included in the annual real estate tax bill for the property, so you can show it to your buyer and say, this is how much it is, so they can decide whether they want to assume it or not.
Visual inspection of property, what's that about?
Well, this is like the as-is provision. It's if the property's not acceptable to the buyer for any reason. It's usually used when a husband and wife are buying. Husband's up in New York. He's going to get here next week. He wants to see it too, or vice versa. You're married, you want your partner to see it before you're fully committed. So this form allows 10 days, if left blank, for whoever to come down, look at it, and see if they like it. And they don't even have to give a reason. They just say, don't like it, and cancel the contract. And again, this can be covered too under the as-is. It just depends upon the situation and how worried they are about their spouse liking it.
Okay. Homeowners documents.
This, we have, under the main body of the contract, we have 2 separate paragraphs. One is a standard H that deals with homeowners associations. The other is standard I that deals with condominiums. They're treated differently under the statutes in this state. Okay? With condominiums, you're given 3 days after the receipt of the documents to cancel the contract and get your money back. It doesn't include the day you get the documents. It doesn't include weekends or or holidays. This HOA addenda gives people buying in homeowners associations that same opportunity.
Okay.
Because the way it is right now, under the Florida statutes, if you have the HOA disclosure attached to the contract when it's signed, there is no 3-day right of rescission.
Okay.
So some agents, some buyers, they want to read those documents.
Right.
There might be use restrictions in there that affect what their kids can do
Right.
within the community. They want to see the financial documents to see whether they have adequate reserves for the needs of the community. So it's an effort to equalize HOAs with condominiums.
Right. Okay, I think that's pretty important that they review all those documents, because some people, they buy a home and, they might not be able to have a motorcycle or, or et cetera.
There are pets. I mean, there's
Right,
been
pets.
litigation in the
Right.
newspaper about putting a basketball hoop at the end of a driveway.
Right,
You've got 4 young kids and you have one of those portable hoops, and
Yeah.
it was against the rules, or
Right.
keeping your garage door open.
Or
It's just-
even flags anymore.
Yeah, yeah.
The next addendum is personal property inventory.
This is one of those forms that I'm not a huge fan of. I grew up, my father's a realtor. I'm the attorney for a real estate company. You want, if possible, when you have your contract signed, to identify all the property that's being sold. And there's 2 ways to do it. And I usually tell agents and buyers, whichever list is the shortest. If what you're buying, if you're the buyer, is 12 things,
Right.
write it out, attach it to the contract, and get a fully executed contract that's not subject to termination 10 days down the road.
Right.
Okay, you get the deal done when you can.
That's right.
Okay, if the list of things that you're not buying is 12 items and you're buying everything else,
Right.
well then identify on an
Exclusion,
exhibit
right.
the 12 things you're not buying, so
Right.
that you can get a fully executed contract that Saturday when you have the people sitting around the kitchen table and signing the documents. You want it to be as clear as possible. Now, in a perfect world, if I were still in law school, this would be perfect. Because you know exactly how many spoons and forks and exactly what's being done, and it gives the seller 5 days to give notice to the buyer on what they think they're buying. It gives the buyer a certain number of days to say okay, and if they don't agree, then it's terminable. I don't see many people doing that. I honestly don't. And I think mainly because there's a natural urge to get a finalized agreement at that moment.
That's right. That's what I do. Is like you said, I take the shortest list, and it's usually the exclusions than it is the inventory of the home. If they're selling it furnished.
And I hate to say it. I urge people to take photos.
Right.
Because I've had too many examples of appliances being changed,
Right.
of kitchen utensils being changed,
Right.
paintings being changed, TVs being switched out. I mean, people, they're all types and kinds. So, take photos. It also comes in handy under the risk of loss paragraph in our main contract that if something is broken, you have photographic evidence of how it existed when you signed the contract. If you have a hurricane, you have
That's right.
photographic evidence of what was there before the big storm hit.
Okay, and then the last one we have here, Don, is addendum to the contract for a cooperative, co-op. I know we don't have very many new ones coming, but we do have some older ones here.
Well, co-ops are, you don't get a deed when you buy a co-op.
Right.
You get an assignment of a proprietary lease. You get a membership certificate. It's like you bought something in IBM. And they were more prevalent, decades ago when they weren't quite classified as real property.
Right.
And they were being used for a variety of reasons. And if you were going to get a loan against a co-op rather than a mortgage, which you use for real estate, you'd use a security agreement, which is what you have against your car if you're going to loan on your car, or any other tangible property that you're buying. If you're financing it, whether it's a TV or a car or a boat, you have a security agreement, and they call it a UCC1, which is filed with the state. Now, a UCC one, it's a Uniform Commercial Code, boring as dirt,
Right.
but it basically notifies the world that there's a lien against this property.
Mhm.
The security agreement's not recorded. The UCC one is. The important thing in here with the co-op is it gives that 3-day right to terminate that's in condos.
Right.
You know, and that's on the second page. Gives them time to look at the financial situation of the co-op. They look at whatever rules and regs they might happen to have. Knock on a few doors and meet your neighbors and see if there are any crazy issues going on with that co-op. Check out the land lease
Right.
if there is one, and terminate if you're not happy. And it excludes, again, the day you receive it and the weekends and legal holidays.
Don, I think we finished most of the addendums that we were going to go over, and then we're going to take a little short break here, and then we're going to be back with a question from Michael
Okay.
from our website.
Great.
And we'll be right back. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back to the Southwest Florida Real Estate Update. And now we have a question for Don from our website. Don, what are some of the key areas that you would look at or advise our clients to look at in the condo and HOA docs?
Great question, Mike. Condominium documents are thick. They're honest to God, they're about that thick.
They are, yeah.
And it's so easy for somebody who's buying maybe the second piece of real estate in their entire life to miss something significant. Our standard contract, which is over here, has a provision in it that receipt by you, the realtor, or me, the attorney, is not receipt by the buyer. Okay, and with condo docs, again, the buyer has 3 days to cancel after the receipt of all the documents for any reason whatsoever. So I recommend that my clients send the documents to me and get it set to the client. And what we look for, you look in the declaration for use restrictions. And that'll get into pets. It'll get into what kind of car you can use. You know, they might have a rule against
Pickup trucks.
pickup trucks, golf carts, motorcycles, boats.
Lettering on cars.
Anything along those lines. They'll have rules on rentals. They'll have rules on guests, and some of them they'll distinguish between family and non-family guests. My personal theory, for what little it's worth, is that you're not going to charge your family rent in most cases, so they tend to believe that, yes, that's a legitimate visitor or a guest. But non-family, well, maybe you're trying to get around the rental rules by saying they're a guest and you're really getting paid on the side. So they might limit non-family guests to a certain number of days per year. So you look at the use restrictions. You look at the rules and regulations. It gets down to the day-to-day things that would affect your use of the property. You can't hang a towel over the railing, glasses around the pool, things of that sort. If they have a rec room, they might have special rules for that. Frequently asked questions. We'll take the things from the declaration that commonly come up, some of the rules and regs that frequently come up, and condense it into a couple of pages. And then the biggie is the year-end financial statement. And this is one where I recommend that don't sign the receipt for your condo docs until you talk to your lawyer or whoever's representing you, that you actually have the year-end financial. I mean, the year-end financial is assets and liabilities. So unless you've got an accounting degree, you might not know what that is. And the assets will include reserves. It'll include a thing called accounts receivables, which almost always is money owed by the owners of the association. So if you have a big account receivable, they're not paying their maintenance. During the recession, we saw that a lot. We would look for that. And the liabilities, obviously you want to see if there's something big out there. What the management companies tend to give you in many cases is the budget instead of the year-end financial. And it's good to have the budget. I mean, don't get me wrong, but what the statute requires is the year-end financial. And I always tell my clients, You know, the condominium is like a real live person. You want to know, do they have money? Do they have a lot of people who owe them money?
Right.
Is it healthy? Are people paying on time? Any special assessments coming up? Things of that sort. And then you look at your use restrictions and what your plans are. Do you have an exotic animal that you want to bring down there? Do you have a rule against that?
Yep.
Are you going to rent it all the time? What are the rules on that? And then we talk about it on the phone. But good question.
Good question. Well, Don, I appreciate you coming again. I guess we're doing this every month. We're calling it our legal tip of the month. So for our viewers, so I look forward to next month talking to
Thank
you
you.
again.
Appreciate it.
And again, thank you for coming.
Very much.
Thank you.